Great. So good afternoon, everybody, members of the Workers' Compensation Subcommittee and all the visitors that are here with us this afternoon. I called this meeting because I just wanted to follow up on the conversations that we had the last meeting, which was about 2 weeks ago. And as you know, we're going to be discussing 2 presumption bills. And it was or is my understanding that there were conversations taking place amongst these 2 presumption bills between those for, those against, and that there were agreements and non-agreements that took place. So as Laura sent out the email for this meeting, I just in the interest of time as well, because everyone's got other subcommittees and the such, I'm really trying to keep this meeting under an hour at most, if that, because I encourage robust conversation and questions and inquiries, because I will let everyone on this Zoom know that while in my experience, presumption bills are always talked about and then put to the side, and everyone's like relieved whether you're an opponent, well, it's usually the opponents, but I will say that at some point they need to be decided on, and the 2 bills that are being brought forth to you today are definitely very important, and I don't ignore the fact that I've heard from opposition saying, you know, all the legitimate information that's been put out there. But like I said, these bills were not put in willy-nilly, obviously, especially with what has transpired and what is not over, the pandemic. And so with that said, I also spoke to those who are in support, the advocates, and I think it's only fair that there be serious discussion and, you know, whenever decisions are made, that they do be made. So with that said, I want to encourage the members here to have your questions that have been shared over time with, if there are specific people that you would like to pose the question to, please do. And I'm going to start off with mine. And that is to, I'm going to start with 2 specific people because those are emails I actually received and read. So I'll start with Mr. McAllister and Ms. Julie Murray. So let's start with Mr. McAllister first.
Sure.
So it's my understanding that there was some agreement on some aspects of it and then not. So if you could keep it in brevity, Mr. McAllister, I'd appreciate it just for the members' sake. Thanks.
And specifically, I spoke to Mr. D'Alessandro and we came to the consensus that it should be a standalone accidental injury bill, not an occupational disease. Most of the opponents who spoke against it said it shouldn't be an occupational disease. We agree. I can explain you why that's a good idea, but I think most of the proponents and opponents will agree that if there's going to be a presumption bill, that it should be an accidental injury bill and not an occupational disease. With regard to who's covered and the criteria for coverage and retroactivity, there was a discussion but no agreement.
I'm sorry, I muted myself. Can you repeat the last part?
Sure. With regard to who's covered, meaning educators, first responders, those kind of people.
Right.
And with regard to whether it would be retroactive or not, we had to agree to disagree on that. But the agreement that I had in my conversations with Mr. D'Alessandro was it should be an accidental injury, not an occupational disease. And it should be a standalone bill.
Standalone. Okay. I don't know who would best answer this question. So I think I'll say that for Ms. Murray, but okay. Do any of the members have questions for Mr. McAllister? Okay. Ms. Murray, are you here? Is she here? Is Julie Murray here?
She is on the call. I don't know if she's multitasking.
Okay. Okay. Well, then if it's not her, if someone who can speak on her behalf, if there's anyone else.
I think Mr. Daly is also on the call. I don't know if he could also.
Oh, is Mike here? Okay.
I am.
So in her email, she expressed the retroactivity, which I get, but then she also expressed how broad, for instance, my bill. So Delegate Washington's bill is focused on firefighters, police, first responders, whereas my bill is a broad coverage. If the bill were, I'm just saying, if the bill were narrowed to say healthcare workers solely, would that still be an issue with opposition besides the retroactivity that, always comes up? Would that still be?
Madam Chair, the MDC, the Maryland Defense Council, has concerns about the breadth of it. And I appreciate what you're saying in terms of limiting to healthcare. But are you saying that the public safety would not be included in a standalone accident injury bill as well?
No. And now that you've said it out loud, I mean, that's why it's so hard for me to narrow the focus of my bill. Because of that. And as I asked you the question, I probably should not.
No. It's a fair question, but I think that's our concerns remain in terms of the breadth, as well as we agree with Mr. D'Alessandro and Mr. McAllister that any bill, not that we feel it should go, but if it should be a standalone accidental injury. But again, I don't think we can reach agreement as to the remainder of the issues such as retroactivity, presumptions, and the breadth.
Okay, well, so the way I interpret that is you said if it were to move, your particular issue is the breadth of it, but the fact that it would only be considered an accidental injury is okay.
That would be right. The fact that if there's anything, because that's the way they're being litigated before the commission now, they're considered accidental injuries, and they're being litigated accordingly on compensability on those grounds. So we think that that's the way that the analysis should go forth.
So because you just stated that that's how the commission is already taking these cases, is that possibly why and I'm not saying it's not a big issue for MDC or other opponents, but because the commission's already taking cases like this, is it the sense that you feel or opposition feels this is totally unnecessary? Because I don't think it's totally unnecessary, but is that how?
I think the word unnecessary, I don't want that to sound cold and feeling that it's not something that's vitally important, because that's not what the MDC is saying. We're saying, however, that the system is working very well. The commission's doing a great job of the few cases that are going forward on compensability on the COVID-19 cases, whether it be a first responder, healthcare worker, grocery store employee, whoever it may be, that they're being litigated quickly and efficiently. So we feel that it's working. The system's working, so we don't feel it needs to be separately legislated to correct a problem that doesn't exist.
Okay, thank you, Mr. Daly. Delegate Ahrens.
Yes, thank you. Mike, could you do me a favor, just so I get it real clear? Describe to me how an accidental injury works. Tell me how that would all be real quick, if you could.
Certainly. So an accidental injury is essentially looking at the facts surrounding an injury that one claims that occurred at work. For example, if somebody says, I was at work and I was walking down the stairs and somebody left something on the staircase and I tripped over it, fell down the stairs and broke my ankle, that would be analyzed as an accidental injury. And that's why we believe, and the commission has tried these cases, is the exposure itself, tracing it back to where somebody could have got it at the workplace, is an accidental injury. That exposure is the accident.
Okay, so we're already doing this.
We are.
And it's working.
It is.
And the intent of these bills is to get a couple different groups and make them special in some way?
Right.
Okay.
Right.
So, I mean, if I work my restaurant, well, I don't have it, but anyway, when I was in a restaurant, one of my workers got it at work. That's an accidental injury?
Correct.
Okay. All right. I'm kind of confused that we're trying to sit out here. We're doing a whole lot with COVID right now, as we all know. And a lot of the bills we've dealt with, as far as in any types of these insurances, that we're hitting these bills really hard, and we're already addressing them, and yet we want to redefine how we're addressing them. I'm a little bit confused on the need for a bill at this moment, but that was my question. Thank you, Madam Chair.
We agree, Delegate. Thank you.
Delegate Moutz. Delegate Moutz.
Yeah, sorry about that. Thank you. Chairman, what are the groups in the bill that are currently identified to be benefited? What groups are
sorry.
covered? What
Okay,
groups
so
are
you
covered
came,
by the bill?
I'll have Laura list it all because there's a lot.
Sure. We went through this, let me see, at the last meeting. I have a comparison chart that I can send out to you guys. I'm gonna try to share screen with it.
Well, so I can actually probably make it easier for you, Laura. I'm sorry, I'm going to cut you off. So like, let's take healthcare workers, for example. So does that mean all healthcare workers or just healthcare workers in emergency rooms, or how does that, how does it apply? Just use healthcare workers as an example.
Bill
So-
has, the way that the bill is framed as an occupational disease presumption. And so someone has to be employed in a specific industry. And then beyond that, they have to meet these other criteria, like they're suffering from the effects of severe acute respiratory syndrome, coronavirus 2. The individual has been diagnosed with COVID-19 or test positive, or has antibodies, and the individual's duties required the individual to perform labor or services at a location other than the individual's home or residence within 14 days before the onset of symptoms. And then I think there's some additional responsibilities, like the individual would have to provide a copy of the positive test or documentation confirming diagnosis to the employer. I think those are the main highlights of sort of what someone has to show in order to benefit from the presumption. But the stakeholders are talking about framing it instead as an accidental injury. So I don't know how framing it that way might change what a worker would have to show in order to kind of make a case under the new framework.
Thank you.
Was that your entire question, Delegate Mounts?
I think yeah, I believe Laura addressed kind of what I was getting at, and that is just that, we're creating this presumption, and I'm wondering how the bill applies to, or how it would apply. I guess it would be a new concept, calling it an accidental injury. There's a presumption with an accident, I guess. So there's a presumption with the accidental injury, but depending on what you do in any of these protected classes, there's just because you're in healthcare, does that mean that everyone that does healthcare type work, are they going to be in this protected class or this special class of people? Even though they may have been nowhere near.
That is not the intent.
And just to add a little bit, the bill, House Bill 1199, Delegate Valderrama's bill, in the definition of healthcare worker, it's an individual whose primary place of employment is a facility licensed under Title 19 of the Health General article, or an individual employed in a healthcare, home care, long-term care setting, whose duties include direct patient care or ancillary work in areas where patients diagnosed with COVID-19 are treated. So there's a little bit more specificity with health workers specifically as to what type of work they need to be engaged in to benefit from the presumption in the bill.
So that would not include an orthodontist, a person working in an orthodontist office.
I would have to defer to someone on the call more familiar with which professions are licensed under that part of the Health General article. Include direct patient care, ancillary work. I'm not sure how that would be interpreted in practice. I would have to defer to someone else about that.
Are you done with your question, Delegate Mounts?
Yes, thank you.
Okay, I'm going to call on Delegate Charkoudian, and after her, I have an advocate I'd like to call on. Delegate Charkoudian.
Thank you, Madam Chair. Yes, I'm trying to understand so it seems like one of the questions is, who are we covering, right? And so that's where you have the two different bills, and maybe within the bills, proponents and opponents are just kind of thinking through that. So putting that aside for just a second, I want to see if I can understand from folks who represent workers on this call, if they can talk about both the proposal in front of us of shifting from the presumption to the accidental injury, what the implications of that are, and And then also just what has been happening, because obviously we've had COVID now for a while. And so I'm trying to understand what has been the experience, where have the challenges been? And if we sort of take this proposal, which I'm not clear who all is in agreement on it or not, but if we were to take that proposal, would that address the issues that have been the challenges for a lot of the workers up until this point?
Okay,
Not
thank
sure
you.
who exactly is the
Shakutian.
best person to have
Yeah, that, and just for folks on this call, this is not strategic meeting. Nothing was planned, but that was a great segue to who I was going to call on, Delegate Shakutian. So
Okay.
to
That
that
works well.
inquiry. I'm
Thank
going to
you,
call
Mel.
Ms. Denise Riley, who is one of the folks I've been working with on this legislation. And if you could answer Delegate Shakutian's question and any others that were on here, that would be great.
Great. I'm Denise Riley. I work for AFT Maryland. Our union represents workers at the state, county, and city level, and we represent healthcare workers, teachers, all ranks of correctional officers, and so on. What we were proposing was that our members be covered under this presumptive language. I've been working with the other attorneys, and we are totally okay with not making no retro on this, because we never intended that to be in the bill in the first place. We're okay with sunsetting the bill. And as of right now, those who do get COVID on the job, they have contact tracing done. So their employers have the information as to whether or not they got COVID on the job. The attorneys are correct. The first cases that came up were getting the workers' comp. But as we've seen, as more cases have been coming up, more are going to litigation or being denied. So we want to be able to protect the ones that are on the job now in the future if they come down with COVID. And as I said, the contact tracing is there. Their employers have the information, and we would like them to, so when if they go to court on this, the employer can bring the information to show where they possibly got contracted COVID. Okay.
Yes, Delegate
Ask
Shakutian.
a follow-up question?
Yes.
Thank you, Ms. Riley. So I think my question is, and this is sort of me still learning the workers' comp world. So this proposal, again, I'm not sure who was part of the negotiation of this proposal of the accidental injury instead of presumption. Would that still cover what you're describing, or is that still leave the possibility that you'd end up with the challenges even after you're able to contact trace to the workplace?
We are okay with making an accidental injury. Our main concern is just to see that the people make it through this short period of time where they're still being exposed to COVID at the workplace in vast numbers. So we support Delegate Washington's bill, we are very concerned about the fact that healthcare workers, who we've all said we're great and we support you and brought food and clap for them and everything, now we're saying, when it comes, we'd rather cover a firefighter than a nurse. So we want to make sure that they're covered for a short period of time to make sure that that their workers' comp claims are not denied. And as we've said before, we've had people who are in the hospital who've just been fired from their job.
On the phone, sorry.
Okay. That people have just been fired from their job, and they have to go back and fight for their workers' comp.
Thank you, Madam Chair. Got my questions answered. Thank you.
Delegate Ahrens.
Thank you, Madam Chair. Couple things though, we're dealing with a lot of other bills too. We're dealing with, what if we do this thing and this tends to work out and somebody refuses to take the vaccine and then gets COVID? How will that work? Anybody can answer that? I'm sorry. I didn't mean, that's not directed to you, Madam Chair, necessarily.
No, I know. Is there anyone in this meeting that, Mr. Kress, would you like to take that question? No, okay.
I think Rick's trying to get into, by the way.
I'm here.
Okay.
Oh,
I'm here.
okay. Oh, I'm
I'm
sorry.
here.
Mr.
Delegate.
McAllister. I saw Mr. McAllister raise his hand. Were you raising your hand?
Yes, I was. A presumption merely means that the claim is covered unless the employer can show it's not. So the employers preserve all their defenses. It just shifts the burden of showing where the person got the virus from the claimant, who may or may not know where they got it for sure, to the employer, who knows who was sick, who else had it. And also, I circulated a sheet of issues last week to the subcommittee. I hope you all got it, because Delegate Valderrama, it included some ways of perhaps narrowing some of the broad categories that were in your bill.
Hold on a second, Mr. McGowan, I'm sorry to interrupt you, but my question, I don't think that's addressing my question. My question is, if I refuse to take the vaccine because I don't believe in it, and I end up with COVID, am I still covered under workman's comp based on this bill?
You're covered under workers' comp based on this bill or workers' comp law in general. You can still prove you got it from the job. There's no defense to a workers' compensation claim.
Okay, I got that. So the other part would be, and this doesn't necessarily mean for you, but like my son had COVID and he lived with us. We were all together and no one else got it. I do have a friend that claims they went out to the store one time and they came back and got it. I guess my big problem is you don't know when or how you're going to get this. And I wonder how you sit down and assign that I got it here. And I know we do contact tracing, but even that with my son was very, 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 very vague on where he could have gotten, how he got it. And I guess I guess we're throwing straws at something that kind of troubles me to go after a group like this with a large fiscal note and a presumption based on the other things we're currently doing in this. And then Ms. Riley, I think you mentioned something you'd like to have your group under it. I would imagine everybody would like to be under this bill, and that's why I'm not clear on why the bill isn't everybody and it's targeted, and I'm not looking for it to be everybody. But those are kind of a couple things that really concern me about this type of bill with an airborne disease, because it can come from anywhere. You can get it from walking across the street. Any comments? Isn't that so? I guess I should say, right, Madam Vice Chair?
Right. Are you raising your hand, Mr. Pavel?
Yes, I am.
Okay.
May I speak?
You may, in brevity, sir.
Yeah, I will keep it brief. Delegate Ahrens, that's a great question. But the bill is not, as you point out, not meant for everyone. It identifies categories of people who are particularly at risk. And we're in the midst of a pandemic that's not over yet, and we're trying to address an urgent situation that these particular persons are in harm's way. As some have said on these meetings, these firefighters, for example, and these public safety persons, they run to the danger that the rest of us run away from, and they get the exposure, these healthcare workers, that the rest of us don't get. So we're trying to protect them. All they're getting is shifting it to this presumption that allows them then to come into court with this presumption that it presumably happened from this exposure. But they have other requirements. They have to show they actually got it.
I would agree with you that it is for a group. But if I work at Walmart, if I'm a waitress, I'm thinking the same way you're thinking about the people you're trying to protect. These people are there, they're doing the things. The grocery store clerk, I can go right down a list of people that are out there doing their jobs. They may not be the hero that's going to save my life necessarily, but they are people that are doing and performing a major function that I would consider life-sustaining. Yeah, but I do appreciate your comment.
Well, thank you. And so that's all we're trying to protect. Ms. Riley mentioned that this issue of retroactivity. There are many cases that have not yet been litigated, but that go back to last spring, that we feel that they should have an opportunity to avail of this bill as well. And we could agree to sunsetting. The Maryland Association of Justice, on whose behalf I speak, would agree to sunsetting this bill once the pandemic is over. So it kind of addresses, they're kind of kissing cousins, that concept of retroactivity and sunsetting we would submit. Finally, Delegate Charcodian, nice to see you after many years. I took the delegates mediation course many years ago. She may or may not remember. She was an excellent teacher. Delegate, this idea of the accidental injury versus occupational disease, it makes no difference on this bill. It's the issue is really now the presumption. If someone has this in the form of an accidental injury, meaning it happened in a moment's time, they breathed this air while working on a patient with COVID-19 and got it, that's an accidental injury. Now they would enjoy the aspect that they could come into court, presumably it happened from that exposure, as opposed to an occupational disease, which suggests something that takes place over a long period of time, usually in our parlance of the world of workers' compensation. That's why all the parties involved are in agreement. It really never should have been labeled an occupational disease. It sounds like one, but in our crazy world of workers' comp, it definitely fits the rubrics, fits the idea of an accidental injury more than it does an occupational disease. But the presumption will work just as adequately there. So I'm hogging up too much time. I'm sorry, Delegate Verderama, that I'll leave it at that.
I understand, Mr. Favola. Before I get to, in this order, before I get to Mr. Kress and Mr. Linear, I want to give my delegate the privilege, since he's on the committee, and that in case you may be able to answer whatever he's about to ask. Delegate Mouts.
Thank you. So for any of the advocates on the call, Mr. McAllister, so in the way this bill's set up, the presumption is that the bill has a presumption, and we've got these broad categories. Is there a way to put a burden on the moving party in one of those categories to demonstrate that they were somehow in a situation in that capacity linked to an environment where there were, I don't know, there's just a way to sort of refine who is covered. Use the teacher example. I see there's a representative for teachers. So you've got teachers that are in school and clearly they can make an argument they're in school, but perhaps you've got a teacher who something to show, to have some burden on the moving party to demonstrate just the basic requirement that they were more than just in the class. If you know, Mr. McCosh, do you think would that help?
Yeah. Delegate Mouts, one of the things I think we tried to do was to put out some talking points about ways of refining the presumption so it's more narrow. So if you want to put something in there that says the teachers have been in the classroom, if there's no exposure, meaning the employer, the school can show, and they have the records in terms of what kids tested positive, they're taking temperatures every day. If they can prove that in all likelihood, keep in mind, we're talking about a preponderance of the evidence, not beyond a reasonable doubt or not to a moral certainty. Is it more likely so or not so that the teacher likely got sick at school or got sick someplace else? And there's basically three ways that the employer disproves that. Number one, we took precautions. We have contract tracing. They have that information. Nobody else was sick. No kids reported sick. No kids called in sick. Number two, we honored best practices. Masking was enforced. Social distancing was enforced. So we did everything the CDC said we should do. And the third is, and this is an amendment that I've proposed that nobody asked me to do, but I think the bill should include something that permits the employer to ask the employee who's seeking the presumption, have any of your family members or cohabitants tested positive for the virus during the 2 weeks prior to getting sick, which is the 2 weeks that the presumption applies to. So if I want to use the presumption, I should have to tell them, did any of my family members or cohabitants have the virus? Because that gives them an insight into a potential other cause. So that's a way of narrowing it. The bill itself narrows healthcare workers to people who work with healthcare workers. So that way the dental hygienist who's working with somebody who's asymptomatic that's not a presumption case. With essential workers. I've proposed an amendment that essentially says only those workers who can only do their job outside the home. So if you're working in a grocery store, you can't phone it in or work remotely. Versus me as a lawyer, I could work remotely, but I choose to go to the office because that's where my files are. That doesn't make me a necessary worker, but the people who can't phone it in, who had to go in and stock the shelves and work in the restaurants, the bus drivers that drove all the nurses to the hospitals, those are essential jobs where you can't do the job without leaving your home. Those are the people I think the presumption bill was designed to address. So those are some of the amendments that we've proposed to narrow this so it isn't a blank check.
Thank you, Mr. McAllister. On that note, Mr. Kress, Mr. Lanier, and whoever else will be raising their hand or not, or who are, I'm sorry, based on everything that was just discussed and what Mr. McAllister just expressed, whatever it was you were going to say, if you could, all encompass everything that's been said, because as I told the members of the subcommittee, this is with the time frame that we are in now, with the session ending in a couple of weeks. Thank God. In a way, thank God. This is more than likely going to be the last subcommittee meeting, but I encourage ongoing conversations. So with that said, Mr. Kress.
Thank you, Madam Chair. I am representing both the school boards and the Maryland Hospital Association. Starting with the school boards that collectively self-insure, we've had 0 denied claims, 0. And so my point to the subcommittee is, what problem are we trying to fix by making an accidental injury presumed to be compensable in this case? What you're going to do is you're going to take these claims that are being processed in normal course, and then you're going to take all COVID claims that are positive, and you're going to make them compensable claims. And before you do something that's so far afield from what's the normal course of practice in workers' comp, we ought to at least see where the problem is. And the claims that we look at from the Hospital Association are very minor, and many of them are being accepted. The fact of the matter is there aren't that many COVID claims because they're in full protective gear. And so let me just say one other thing with respect to retroactivity. The statute of limitations is 2 years. So there is no need for retroactivity. So I'm a little at a loss on why we're going down this road without any real evidence of a problem.
Okay,
Thank you.
Thank you. Before I get to you, Mr. Lanier, based on what Mr. Kress said, Ms. Riley, I'd like you to respond to Mr. Kress's testimony.
Yes, we have had cases where people have been denied, or there's still the litigation pending. So as we said, the information is on the employer's side as far as what the contact tracing was. So as Mr. McAllister said, it's just a matter of being able to, the employer can show that they got the disease from someplace else. And but as we said, we want to make sure that the people are covered in case they're denied, and then the people are protected in case that this is they don't have the kind of information that that the employer has.
I have to sneeze. Okay. Whew, no.
Oh, can I just say with the teachers, the teachers who become sick on the job, again, if there's not, it's easy to trace when there's an outbreak, but if one teacher becomes ill and everybody else is fine, then that's pretty obvious that there wasn't an outbreak in the school.
Thank you, Ms. Riley. Finally, Mr. Lanier, I apologize.
No, thank you, Delegate. I just wanted to really quickly respond to the Delegate Arendt's actual question. He used the word deliberate, which is willful misconduct is already a defense in the Workers' Comp Act, and it would apply to anything having to do with COVID or, quite frankly, any claim. So the idea that someone would do something deliberately, willful misconduct would always be a defense to that claim, no matter if it's an accidental injury, an occupational disease, hernia, hearing loss, whatever. I can't imagine a hearing loss being deliberate, but that is already a defense in the act and should hopefully belay any concerns you have with someone just out and out refusing to get a vaccine for whatever reason.
Were you done, Mr. Lanier?
Yes, ma'am. I don't want to repeat everything. I mean, that was a
Okay.
specific question. I don't think anyone answered it, so I wanted to try that.
Okay, Delegate Aaron's.
Yeah, I guess briefly, I would think Ms. Riley made a comment about there's some cases out there that haven't been resolved or were rejected. And I would think that I appreciate presumption, all that stuff, but I would think that if it wasn't something that was part of the job, that why would you want to be included? Why would we want to use this product that we have that's supposed to be a benefit to the employee and the employer in a sense? If it was something where I was out all weekend with some friends and I caught it, why would I want to assume that it was part of my job? I just don't, that doesn't make sense to me. And I appreciate that these people still need to live. And I think we're doing a lot of stuff to help people through COVID. So I just wanted to make that statement. Isn't that so, Madam Vice Chair?
That is so, Delegate Aaron's. Thank you.
So you're the chair. That was for my vice chair.
All right, I apologize. Spring has come and allergies are kicking in, so sorry about that. And if I may, I'd like to take a point of personal privilege. There's folks on this call that I have had conversations with over time since chairing the subcommittee, and I apologize if I'm putting you on the spot, but I'm sure this is not new to you. But I'd like to ask Mr. Carl Alman, who's the head of the Workers' Comp Commission, and ask what your thoughts are. And you may have said this in the last meeting, I don't recall. In your position as, we're seeking the need for changes to the current law, would you kindly share with the subcommittee members your opinion on behalf of the commission? Is he here?
Yes, Madam Chair, can you hear me?
Yes.
Great.
To see you, miss your face.
Yeah, sorry. Well, no, not really. You shouldn't. But anyway, this is the best way to deal with me. No, I'm happy to provide some background facts, just so that the subcommittee members understand, how we've been progressing, because that may give them a little bit more understanding. We currently have about 1,250 cases where COVID is alleged to be part of the claim. Now, not to muddy the waters, but some of them are a little bit strange. We have a couple of car accidents that people have been involved with as they've gone to be tested for COVID, and that gets thrown into the mix. But let's say it's fair to say that well over 1,100 of these 1,250 claims are undoubtedly where people are alleging that they were exposed to COVID at work. I would say that we're getting to cases pretty quickly, in spite of the fact that we were basically closed down for a few months. We went back to hearings in person in June. Unlike the court system, we went back to hearings. We went back to operating in person, though not at the volume that we used to be able to, but certainly getting cases heard quickly. We probably right now, there are cases that are in line for hearing since October have been set in for hearing already. So our backlog is not great, but it's not as terrible as it might have been. Point being that a lot of these cases are moving ahead, and I'd say that out of that 1,100 cases, about 700 of them, 750 of them are receiving some sort of benefits, TT benefits. We have, as far as our numbers are concerned, adjudicated claims, 24 disallowed claims out of the 800. We've had 880 COVID cases heard by the commission. So I'd say that the vast majority of claims are being accepted either directly by the employer insurer at the beginning or by adjudication before the commission. So we're moving ahead, and that just sort of puts a little bit of meat on the bones for the committee to consider.
Okay, so is that all of that to say you're saying, or I'm interpreting, that you don't see a need? Is that a way to interpret what you just said for these laws that we're proposing?
No, well, yeah, we don't take a position on benefit bills. It's not our place to do that, really. At least I don't think it's our place.
I see. Okay.
But I think it's important to note that the claims that are being filed, the vast majority of them are being accepted. There aren't lots and lots of claims that are being denied, is my point.
Okay. Wait, you just said that there weren't claims being denied. Is that what you said?
Right. There.
Okay, so based on
That's what I
that,
said.
I don't know if you heard.
There are relatively few.
Okay, so when you heard, if you heard Ms. Riley just a few minutes ago say that there were claims that are still in holding, or I don't know what the right word is to use, what would be your response to that?
There may be claims that haven't been, there may be injured workers who have potential claims that haven't filed them yet, that aren't getting benefits, but there's nothing that there are a relatively small number of claims that the commission has denied as the cases have come before it.
Okay. All right. Thank you, Mr. Alman. I'm going to call on Delegate Charkoudian. After Delegate Charkoudian, I'm going to ask if there's a representative here who I've been having conversations with. That would be Mr. D'Alessandro. If he's on the call or the representative is, I'd like you to go in response to everything that has just been said and asked from the subcommittee members. Delegate Charkoudian.
Thank you, Madam Chair. Mr. Alman, I just had a follow-up question. I guess I appreciate that you are not necessarily going to take a position on the bill, but I'm wondering if you can tell us what would be different if this bill were in place, if either one of these bills were in place. And in particular, I guess I'm wondering, you said there were 800, did you say 800 cases in front of the commission?
No, 1,250.
1,250 cases went to the commission and 800 were...
800 have actually been heard.
So there's 450 that haven't.
That are in line, correct.
That are in line. Okay. So does the change to the law related to COVID, sort of this proposal we have in front of us, would that either potentially keep cases from going to the commission because there would be clarity of legislative intent, and or would that move anything any faster so that these individuals wouldn't be in line waiting?
Oh, that's a little speculative for me to really say whether they'll move ahead or not. I mean, that's up to the claimant and their attorneys. But anything that, when a claim gets filed, it gets put in line immediately. And if it's in a contested posture, meaning that there's a fundamental question of compensability, that gets our highest priority. So we try to put those in line more quickly than the others.
I'm just wondering, I guess what I'm trying to figure out, again, because I don't know like the ins and outs of the commission process, is if the legislature were more clear about, which this sort of directs, like this is what we believe to be, I guess this would be an accidental injury is what we're describing it as now. Does that change potentially, like if you look at other laws that we have on the books, does that potentially change how much people contest the filing? You know, are people more likely to accept that this is what we intend to include within workers' comp?
Madam Chair, if I may, I'm wondering if Delegate Charkoudian, if you're asking about the people that are waiting, they've already filed their claim, but they're waiting for a hearing. I think that the effect that a bill would have on them depends on whether you all leave in a retroactivity provision, which some of the advocates were talking about. I don't know if that's what you're talking about, but I think that the only way that this legislation would affect them is if there's a retroactivity provision. Otherwise, it would be prospective for claims filed after the effective date.
Thank you. I do appreciate that. That's very helpful. I guess I'm asking a different question, or that's I'm trying to take, like, everyone's sort of taking the past 12 months and saying, look at the past 12 months. This shows either that on the one side, we do need these changes to law. And then others are saying, if you look at the past 12 months, it tells you that we don't need these changes to law, right? So we've got both of those in front of us. And I guess what I'm trying to understand is from the perspective of Mr. Almond, who I understand you're not taking a position on this bill, but I'm just trying to hear from you what you think, and maybe you can't answer the question, but if this had been in place, so understanding it's not going to affect those actual 450 people, but if this had been in place, would those have moved faster? Would there be less likely for folks to have contested those cases? That's what I'm trying to wrap my head around, these two sort of concepts that are in front of us, I guess. And if you can't answer that question, that's fine. And maybe someone who speaks later will jump in on their perspective on it.
Delegate, let me add, like everything else with COVID-19, it's new territory. And, we've never had a situation where we've had this many cases filed regarding a particular situation, be it an accident or an occupational disease. It just hasn't happened before. These cases are factually dependent. We need to find out what's going on. It's not like a typical case where you might have an occupational disease that involves cancer or heart disease or Lyme's disease. There's much more medical information that you're dependent on in those cases than you are in this case, where it may be, where did it happen? That's a totally different paradigm for us. And we're capable and are, doing, I think, a pretty good job of dealing with it, but it's very factually dependent. So it's a matter of the testimony of the claimant and any of the witnesses that are brought in. And in the cases that I've heard, there are frequently witnesses brought in to talk about the exposures and potential exposures. So in answer to the question, it's new territory. It's really not possible to say that if the presumption had been in place before, or if it included a retroactivity component of it, would it make any difference? I don't know. I just really can't say. They're so factually dependent. We have to rely on each particular case and the way that they're presented.
Okay. Thank you, Madam Chair.
Okay. Is Chesapeake represented here? Is Carmine or Pilar on here?
Here. Hello, Chair Valderrama. This is Pilar Clemens from Chesapeake. Can you hear me?
Yes, thank you.
So, I won't belabor anything we talked about in the other meetings or hearings or covered today, but, just to sum up, I think, Chairman Almond's perspective and figures help make this point. Given the numbers and what we're seeing and what we've seen and heard from other groups, this just doesn't seem necessary. The system's working the way it was intended to, even with a curveball with increased number of cases in a relatively short amount of time. The system's still progressing. Claims are getting through. People are getting benefits, and we have a great system in Maryland, and it is working. Delegate Charkoudian, to your question, it seems, if we're thinking in terms of what if and what would have happened if this was in place then, there were so many pieces of the litigation system that were, thrown for a loop when this pandemic first happened. And I don't know that workers' comp was immune to that either, but I think based on what we've seen and the numbers we've seen, excuse me, and Chairman Almond's testimony and figures, it's working, and it's working well now. So, we just don't see the need for this bill. It's not warranted based on what we've seen. And that's not to say, COVID-19 hasn't had a huge impact on Maryland and Marylanders, but we just don't see the need for this bill. Any other questions, if anyone has any?
She referred to you, Delegate Charkoudian. Are you good? Okay. With that said, and also, as I said in the beginning of this meeting, I definitely just wanted to get everyone's questions, especially from the members out there or commentary or otherwise. And I did call in some people because of conversations that I've had personally. If there are folks on this call, on this Zoom, that would like to share something, and I do that hesitantly because I don't want to be on here longer than we have to. If there's anyone on here that wants to say something that has not been covered or hasn't been said or anything like that, this is the time. I'm trying to see both screens here. Mr. Erlinson.
And if you hear me, I just want to make the one point about retroactivity in that in the past year, how many what have been described by the media as super spreader events have occurred. Various holidays, religious holidays, summer picnics, etc. And I think that has to be factored as far as considering retroactivity is concerned and trying to go backwards to make these cases somehow compensable. And the impact of the presumption has no effect on cases that have merit. Cases that have merit are presented before the commission, and if they have merit, they're found compensable. The concern is the impact on cases that do not have merit. And those cases are the ones that we are concerned about, that by reason of the presumption, if you establish you're in the favored class and you have COVID, boom, the presumption attaches. And in the absence of what I would submit be a significant amount of evidence, that claim is found compensable. That's what we are concerned about. That's all I have to say.
Thank you, Mr. Erlinson. Is there any commentary or questions for Mr. Erlinson? Okay, so, all right, so.
Thank you.
Ms. Riley, I will defer to you for one more shot. If you need anything else you need to say. Again, my members here, everyone's got crazy schedules today. So if you've said everything you'd like to say, do you have?
Yeah, as I said, we just want to make sure that our members are covered in the future as the claimants have, as the cases have become more likely to be denied, and even based on the fact that they have the contact tracing that can prove that they got sick on the job.
Okay, thank you very much, Ms. Riley. All righty, so with that said, going once, twice, thrice, if anyone has anything to say. Okay, I really appreciate everyone joining with the members and myself. Whether you thought this was productive or not, I thought it was productive. And I'm sure some of the members did as well. And if it was repetitive, I apologize. But I think the last meeting, not everyone got to speak and not a lot of questions were answered. So with that, I'm very appreciative. And if anyone wants to reach out to me, I'm happy to have more conversation. With that said, I just thank everybody for that. And there's folks on here who have been reaching out, and we will just continue those conversations. I appreciate it. Thank you.